Welcome to HR ListenIn, the free monthly podcast from the employment team at international law firm Taylor Vinters. We hope you enjoy the show.
Hello and welcome to the January 2016 episode of HR ListenIn. I'm Dom Holmes, an employment lawyer in Taylor Vinters' London office and presenter of HR ListenIn. For our first podcast of 2016, I thought we'd kick off the new year by looking at some recent cases dealing with misconduct investigations and misconduct dismissals. Now, the basics are well established: carry out a thorough investigation, be clear on the allegations that the employee has to answer, follow a fair disciplinary process, and if there is a finding of misconduct, consider the appropriate sanction in light of any mitigating circumstances. Now, that sounds quite simple, and obviously there's a lot more to it than that. Certainly from a practical perspective, dealing with misconduct issues is often time-consuming and can give rise to sensitivities that cause wider issues across the workforce. But if you follow those simple rules, you'll be starting from a strong base if you have to defend a claim for unfair dismissal. Now this week I'm joined by my Taylor Vinters employment team colleague Kate Ledwidge. Welcome, Kate.
Hello. It's true that misconduct investigations and dismissal processes do often take a lot of time and effort, but it is important to get the process and the decision right. There were a few cases towards the end of last year which really emphasise that.
So Kate, just to tee up the discussion, I think it's worth having a quick reminder of the basics. So employees with at least 2 years continuous service have statutory protection against unfair dismissal. And a dismissal will only be fair if, firstly, it's for a potentially fair reason, and misconduct is one of those reasons. And secondly, the employer follows a fair procedure and, importantly, acts reasonably in treating that reason as sufficient to justify dismissal.
Absolutely, and in particular, the dismissal must be within the band of reasonable responses, which are open to the employer in the circumstances of the case at hand.
Absolutely, and we're going to look at 3 cases in particular, Kate.
Yes, specifically we're going to look first at the role played by HR in disciplinary proceedings. We'll also cover a couple of examples where 2 employees were disciplined in relation to the same incident, but in each case only one was dismissed. So we're going to look at what extent an employer can justify applying different sanctions when both employees were found to have committed an act of misconduct.
Okay, so let's start with the role of HR.
So in most cases of alleged misconduct, first and foremost there needs to be an investigation. Then, depending on the findings of that investigation, there may need to be disciplinary proceedings. If a sanction is applied, whether that be dismissal or demotion or even just a warning, the employee should be given a right to appeal. And the employer needs to give careful consideration as to who conducts each of those 3 stages. Ideally, it should be someone different at each stage.
And often, Kate, that will be a line manager who may understandably need some guidance from HR.
Absolutely. HR is often the common thread throughout the whole process. Depending on resources, different HR professionals may need to be involved at different stages, but it's absolutely normal and appropriate for those dealing with disciplinary matters to ask HR for guidance, in particular in relation to the company's disciplinary procedures or how matters are typically handled within the organisation.
So HR will usually be present at an investigation meeting, a disciplinary hearing or the appeal hearing.
Yes, they will often take notes of a hearing, but their role often extends beyond that. They are a sounding board for the decision maker about what the evidence points to and, if proven, what kind of sanction feels right. This is perfectly legitimate. However, there is always a danger of overstepping the mark.
So, Kate, you mean where HR becomes more of a driving force behind the decision itself?
Exactly, and this is what happened in a case called Rampal against the Department of Transport. In this case, Mr. Rampal was employed as an aviation security inspector. His work required him to travel, and he was entitled to claim certain expenses. He was issued with a company credit card, but personal use was expressly prohibited from that credit card. On an audit of his expenses, around 50 items were flagged as requiring further investigation. Mr. Rampal was able to explain these items, and so it went no further. However, a few months later, further concerns were uncovered, including excessive petrol use and other suspicious purchases that raised red flags to the business.
Okay, so that sounds like potential misconduct territory. So what did the process look like, Kate?
Well, a manager, Mr. Goodchild, was appointed to deal with the disciplinary proceedings. He did not have previous experience of handling such matters, and so he met with HR and familiarised himself with the disciplinary procedure and the handbook. In particular, he wanted to understand the differences between misconduct on the one hand and gross misconduct on the other, and the appropriate penalties for each. So, following a disciplinary hearing, Mr. Goodchild supplied his report to HR. The report was partially critical, but also concluded that a number of the explanations given by Mr. Rampal were plausible. Mr. Goodchild therefore recommended a finding of misconduct and a final written warning as the sanction.
Well, that sounds fair enough. So how did Mr. Rampal end up being dismissed?
Well, there were some lengthy exchanges between HR and Mr. Goodchild, and eventually, after going back and forth several times, he completely changed his mind. In the end, the employee was found guilty of gross misconduct and then dismissed without notice.
So the Employment Tribunal said it was an unfair dismissal then?
Well, actually, no. The Employment Tribunal said it was fair. It said that the decision was one within the band of reasonable responses for the employer. It was the Employment Appeal Tribunal who reversed that decision. It said that the dramatic change in approach after HR input was disturbing. HR had effectively persuaded Mr. Goodchild to arrive at a different conclusion than the one he'd made up for himself.
So the HR manager had strayed well beyond the scope of what was acceptable there. And I presume that the report was just no longer considered to be the work of Mr. Goodchild.
That's right. So the case has gone back to the Employment Tribunal to be reconsidered.
And what can we learn from this case then, Kate?
Well, I think it shows that HR professionals have a fine line to tread when supporting disciplinary processes, particularly where managers have no prior experience. To my mind, the golden rule is that the decision needs to be that of the disciplinary officer, in this case the manager. Guidance can be given regarding procedure and what options are available. However, HR should not seek to influence or persuade a manager in relation to the ultimate decision.
So what we're saying is that what should have happened here is that there should have been a final written warning.
Yes, remember that Mr. Goodchild went to some effort to understand the different forms of misconduct and their associated sanctions. He looked at the evidence carefully and then made a decision. The misconduct was not serious enough for a dismissal. It was not the HR team's job to lean on him for a different outcome, no matter what other internal pressures there may have been.
Okay, Kate, let's move on to our second case then. And this one concerns a long-serving employee with a clean disciplinary record who was dismissed for breaching a health and safety procedure.
Yes, this is the case of Newbound against Thames Water Utilities. So in this case, Mr. Newbound carried out inspections and maintenance work in sewers. He had 34 years of service. Prior to a sewer inspection one day, he was taken through some safety requirements by his line manager, and these included a relatively new health and safety form, which required him to use full breathing apparatus when working in this particular sewer, because it was a confined space which gave rise to additional risks. He signed the form to confirm he had read and understood its contents.
And let me guess, he didn't wear the breathing apparatus.
Correct. He went down into the sewer with his supervisor, Mr. Andrews, who was relatively inexperienced, and they were spotted emerging from the sewer without breathing apparatus, and they were reported. Mr. Newbound was dismissed instantly for gross misconduct. In contrast, Mr. Andrews was only given a written warning.
So, what did Mr. Newbound say about that?
Well, he admitted that he'd not used the breathing apparatus, but he said that he'd relied on his experience to assess the risk, which he considered to be low, given that a gas monitor had not given a high reading. He also said that he'd not appreciated the significance of the health and safety form. Basically, he'd signed it without reading it properly. He also said he was prepared to undergo any refresher training that was necessary and asked his employer to take into account his substantial 34 years of unblemished service.
But it seems that was ignored though, Kate. So he brings an unfair dismissal claim. And what did the courts make of it?
Well, the Employment Tribunal said it was an unfair dismissal. It said that no reasonable employer would have dismissed in the circumstances, and there was no justification for Mr. Newbound to be treated differently to Mr. Andrews. However, That decision was overturned by the Employment Appeal Tribunal. However, then the Court of Appeal restored the finding of unfair dismissal.
So it was a bit of a roller coaster ride then, Kate. And what made the Court of Appeal find in Mr. Newbound's favour?
Well, it said that the health and safety document had only recently been introduced, and Mr. Newbound had not been trained on its significance. He'd also previously made his own judgment calls on whether he should use the breathing apparatus or not, and previously this had never resulted in disciplinary action.
So in effect, what the court said is that the employer had always been prepared to rely on his experience over the previous 34 years, so why not now?
Exactly that point. Thames Water tried to use this against him by saying that he should have known better, but that was rejected. It also argued that because it was a health and safety matter, an employer should be given a very wide discretion when considering whether dismissal is appropriate. But the Court of Appeal confirmed that there is no special rule when considering health and safety breaches.
And what about the issue of him being dismissed when his supervisor wasn't?
Well, it's a good point, Dom. The court did not like that at all. The supervisor, Mr. Andrews, was in overall charge on site, and he twice allowed Mr. Newbound to enter the sewer knowing he wasn't taking breathing apparatus with him. He was interviewed during the disciplinary investigation, whereas Mr. Newbound was not, and he was not dismissed. The court said it had rarely seen such an obvious case of unjustified disparity.
Well, I wonder whether a different tribunal might have reached a different conclusion there, and you can certainly see the argument for a zero-tolerance approach where health and safety is concerned.
Yeah, I suppose that's true to a certain extent, but Thames Water ignored many of the golden rules. A robust investigation is crucial to the fairness of the overall process, and employers are judged by very high standards when seeking to justify misconduct dismissals. In this case, the employer made a basic error by not interviewing the employee who was being investigated.
And I guess the killer blow there was that Mr. Andrews, the supervisor, got off fairly lightly.
Yes, he escaped dismissal despite being on site and having overall responsibility for the work. And Mr. Newbound had previously been allowed to work without breathing apparatus. No one had told him that something that was previously allowed could suddenly be considered sufficiently serious to justify summary dismissal, another golden rule.
I think it's also important to separate out a decision on whether there is misconduct from a decision on the appropriate sanction to be applied. And it doesn't necessarily follow that all cases of serious misconduct justify summary dismissal. And there were significant mitigating factors here, I think.
Right, let's move on to our final case. And this is one that you've looked at closely, Dom. And another example of two employees doing something wrong, but only one of them being dismissed.
Yes, Kate. Now, this is a really interesting case of NBNA against Jones. Mr. Jones, in this case, employed by a bank. Bank holds an event at Chester Racecourse to celebrate its 20th anniversary, which Mr. Jones attends. And prior to the event, employees were told that it was a work event and the normal standards of behaviour and conduct would apply. Now, what happened is that Mr. Jones became involved in an argument with another employee, Mr. Battersby. They'd both been drinking quite heavily, and in the end, Mr. Jones punched Mr. Battersby in the face. After the celebration had ended, Mr. Jones and some colleagues go to a nightclub. Mr. Battersby knows he's there. He waits outside for him, sending him a lot of abusive text messages threatening violence, although in the end he didn't carry out those threats. Mr. Jones admitted to punching his colleague in the face and was promptly fined for gross misconduct.
Okay, but not Mr. Battersby?
No. So the same manager, a guy called Mr. Horsfield, dealt with Mr. Battersby's disciplinary process as well. Now, he described those text messages as of an extremely violent nature and wholly inappropriate. And he also later conceded that they were sufficiently serious to amount to gross misconduct. But Mr. Battersby only got a final written warning.
So why was that, if the texts were so bad?
Because Mr. Horsfield concluded that they were made as an immediate response to Mr. Jones hitting him, and that was seen as a mitigating factor.
Okay, but weren't they made sometime later, outside the nightclub? It doesn't sound like an immediate response to me.
Exactly, and that's what the tribunal said in this case, Kate, and it ruled that dismissal was not a reasonable outcome on that basis. Further, whilst both employees stated that they had been provoked by the other one, Mr. Horsfield had applied some sort of provocation test and applied it differently in both cases. So it found the dismissal to be unfair, But the Employment Appeal Tribunal overturned that, and it said that dismissal was fair.
But that sounds similar to the previous case we discussed. 2 employees guilty of similarly serious conduct, but only one was dismissed. Is that really a fair dismissal?
Well, I think it's certainly not uncommon for claims of unfair dismissal to result from some kind of actual or perceived difference in the way that one employee is treated from another, where the circumstances are broadly comparable. But the Employment Tribunal fell down here by not focusing on what Mr. Jones had done. If it was reasonable for the bank to dismiss Mr. Jones for thumping another employee in the face, the mere fact that it was unduly lenient on Mr. Battersby was irrelevant.
That seems slightly contradictory to the case we just discussed, but perhaps I guess the big difference here, as opposed to the employee who breached health and safety when working in the sewer, was on process. In the Newbound case, the employee who was dismissed was not actually interviewed during the investigation, unlike the employee who kept his job.
Yes, I think it was that, Kate, together with the employer having previously condoned that employee's conduct over the previous 34 years. Now, obviously, that didn't apply here. An employee who punches a colleague will rarely have any cause for complaint if he or she is dismissed, absent some very compelling mitigating circumstances.
Yeah, but even if the colleague retaliates?
Yes, I think so, even then. The court said that disparity of treatment is only relevant to fairness in quite rare circumstances. So, for example, where there are what it calls truly parallel circumstances. Here, Mr. Jones punched Mr. Battersby in the face at an event where the expected standards of behaviour were made clear. Mr. Battersby's text messages sent later that evening were not truly parallel, although obviously the EAT acknowledged that they were what it called plainly reprehensible.
Right, so what do you think we learned from this case?
I think at first glance it may seem quite odd that 2 employees who committed acts of gross misconduct in relation to each other on the same day could be treated so differently. One lost his job, the other did not. However, it shows the flexibility available to employers who are considering whether it is appropriate to dismiss an employee.
So that takes us back to the band of reasonable responses test again. The law recognises that there may be a range of reasonable ways in which an employer might consider any particular situation.
Absolutely, Kate, and it is not the job of the Employment Tribunal to substitute its own view for that of the employer. In this case, the NBNA and Jones case, it was distracted by the different decision that had been taken in relation to Mr. Battersby. It should have concentrated solely on what Mr. Jones had done.
But if you look at what Mr. Battersby had done, I don't think the employer could have been criticised for dismissing him either, if that is what it had chosen to do.
Yeah, I would definitely agree with that. It sounds like he was quite lucky in the circumstances, but that was not relevant to whether it was reasonable to dismiss Mr. Jones. Well, that's about it for this month. Some really interesting cases there, and hopefully some useful pointers for our listeners. It's been really great to discuss these issues with you, Kate, and if our listeners want to get hold of you to discuss them in more detail, could you remind them how to do that?
Yeah, thanks, Dom. Well, all of my contact details are available simply by searching for me on the Taylor Vinters website, which is www.taylorvinters.com, and you can also reach me by email, kate.ledwidge@taylorvinters.com, or via LinkedIn.
Thanks, Kate. And next month I'll be joined by another member of the Taylor Vinters employment team to discuss more practical HR issues. You can access all previous editions of this podcast by clicking on the ListenIn icon on our homepage, where there are direct links to the web pages of all presenters. And for those of you who are active on social media, you can also find me on LinkedIn and on Twitter @DomHolmes147. Thank you for listening in to HR Listening.